endemic problem within, certainly in the family court, and I would hope, I'm confident in saying, neither in the Federal Circuit Court of Australia. That's something of which we're very attuned. We have a joint courts committee on the family violence and all of these things. The family court commenced it in the mid-1990s, and it's revised, reviewed regularly, and it's an ongoing and active process that we engage in.
Well, I'm pushing for a Senate inquiry into the family court and child welfare agency, so I suspect we'll talk again. I thank you for your time.
Not at all. Thank you, Senator.
Thank you, Chair.
Thanks, Senator Hinch. Senator Waters.
Yes, thanks very much, Chair. Good evening there. Hi, folks. I'm not sure if we'll need yourself, sir, or the acting registrar, but I too have some questions about processes in the family court, particularly as it pertains to domestic violence cases, including the issue of cross-examination, amongst others. But firstly, I wanted to ask whether yourself were you acting registrar?
Principal registrar.
Principal registrar. Okay. Have you in that capacity or anyone else as a part of the family court engaged with Women's Legal Services Australia about their plan Safety First in Family Law?
We did, and we have, and there are a number of the agencies that we have links with and consult. And I think, as does the Federal Circuit Court, I can't talk definitively about that. The acting principal registrar, CEO Mr. Argos, can, no doubt, and Fenwick can talk about that. But they're amongst the various agencies with whom we work across a range of the protocols, principles, guidelines that are applied with professional staff, counter staff, guidelines and benchmarks for judges. I'm conscious of that recent report, which I think, in fact, the Chief Justice may have been, I think, provided with a copy some little time ago, and they are things about which we take on board always and listen to and see what we can do to achieve. We've got a process at the moment going, which I've initiated for the registrars who deal at the lower level with these cases, about looking at our process, our models, the best practice guidelines and benchmarks. Nothing's ever immutable, I think, in either court insofar as how we don't consider that. We think they're dynamic and they have to be considered and reviewed and revisited regularly to make sure that whatever we've got in place is working appropriately, and we consult widely.
Well, that sounds very positive. Are you able to provide me with a little more specifics on the particular recommendations in that 5-point plan?
I've just received it today at 12:30 p.m.
I thought
Senator.
You said you were engaging with them
and
on the plan.
I'm happy to, if there was something to take on notice for you, and I apologise, but I'd received it just this afternoon at 12:36 p.m. I recollect.
Okay, so your engagement with Women's Legal Service has been on general matters, not on this plan specifically?
Well, not on that particular, not in my role, at least at this point in time. No. Okay,
and are you aware whether anybody else in the court has engaged with this plan and with Women's Legal Services on the details of this plan?
I would have to check and, if I may, take on notice and come back to you on
Thanks
that. From the family
much.
court's perspective, I don't know about the Federal Circuit Court, but
I'm not sure how relevant it would be, but by all means...
75% of the cases are dealt with in the Federal Circuit Court, and most filings are initiated there and commenced there.
Is that right?
So that we only deal with the small
please.
percentile, but we complement each other with the processes.
Well, in that case, I'll also ask your colleagues, I'm sorry, is that yourself in the middle, sir?
That's correct.
Dr Fenwick, have you had any engagement with Women's Legal Service specifically about this Safety First in Family Law plan?
I'm also not aware of any specific formal approach or consultation.
Okay. And yourself, Ms Lagos, is not relevant for your jurisdiction?
Not relevant to the Federal Court, Senator.
Great. All right, well, I'm pleased to see that you've received it today, and it certainly has what seems to me to be some very sensible reforms. And can you outline for me what the process will be from here on in for the court to turn its mind to these sorts of reforms?
I think the most formal process will be there is a continuing joint committee of the two courts, which is chaired by two judges and which has a reporting mechanism to the Chief Justice and the Chief Judge. And that this report will be considered in the overall construct of their work, but also looked at insofar as it may be applicable to the current court processes, whether there is a means or way in which that could be implemented, or consider, if it is, how it might be done, or what are the practical problems or difficulties in how it might be. We would always look and see if there's an opportunity within the current process and operations, without any necessarily extra cost or added cost or significant cost to do so,
Sure.
simply in the practical manner. But there may well be other longer term things which we would then consider, and if we need to, we would prepare, I imagine, a proposal or a budgetary proposal about where there might be a case made for funding to enable certain things to occur. But we'd certainly look at what could be done immediately,
Okay.
with a very short timeline
Okay.
to at least commence the process of implementation if there are things which are accepted. Chief Justice has a policy advisory committee of the highest level, and I think there is already a tacit acknowledgement and acceptance that the things and the tenets underlying those sort of recommendations are shared as a concern, and we wish to ensure that all parties to the court process have their needs addressed appropriately.
Thank you. So that Policy Advisory Committee, because you're right that the Chief Justice was at the launch of this plan. I was at that same launch. It was June of
Yes.
this year in Melbourne, and she spoke very passionately about these issues and very well. So I'm surprised that you've only seen the plan today. Do you know if there's been any consideration by that Policy Advisory Committee or any other architecture of the court, given the Chief Justice's particular interest in fact, launching this very plan?
I can't tell you definitively, but I would be quite certain there will be, because there's various arms of the court that must have regard to these things. The policy aspect is that the Chief has given her imprimatur from the Family Court of Australia's perspective to it, and I think is also, wishes to have them implemented. I apologise, I'm at cross purposes with you, I'm told, Senator. I was talking about the report as against the plan, the 5-step plan, which I think the safety first in family law.
Yes.
I apologise, I was at cross purposes with you about a more detailed report that underpinned it as against the actual 5-step process, which
Yes,
has
so the
been seen
5-step
previously.
process was
Yes.
launched in June
Yes,
by the Chief Justice, amongst others.
yes. Well,
I'm interested in what's happened since then. Has the court turned its mind to implementing any of these suggestions
I
as
think
yet?
it's an ongoing process, as far as I'm aware, that the risk assessment is already undertaken. There's already been processes in place for risk assessment. The Family Court also has been doing some tentative study and work about a new evaluation model, which the Chief Justice has given support to for the cases in the Family Court, which is a model to be utilised by family consultants when parties are referred to engage in a process from the earliest stages under Section 11F of the Act.
Yes.
Children's and Parents Issues Assessment, it may be child inclusive, it can be, and arrangements are always had to have a flexibility whereby parties themselves are not compelled to see or confront or deal with each other as a matter of necessity, that's arranged in unique needs of the family, the individuals, but an assessment is taken, a questionnaire asked to, I think it's 8 questions about triggers and indicators about family violence and the level of it.
Okay, so how long's that been in place for, that new
Well,
evaluation
it's only just
model?
had the imprimatur of the Chief to move forward after 2 periods of evaluation over about the last 12, 15 months
Okay.
by Dr Ben Jones, family consultant who's based in the Melbourne Registry.
Okay, so sorry, is that being implemented yet or not?
She's just given made the request following the evaluation to move forward with it. So it will, I expect, commence shortly in a more formalised setting than has been. At the moment, it's been a controlled evaluation process to see if it has been useful and the evaluations before proceeding, to be very careful.
Okay, thank you. So with this new evaluation model, how does it differ from the previous process as it pertains to those family consultants in the domestic violence
It's a more targeted and consistent
space?
process.
Hang on, let me finish so
I'm
we don't
sorry.
get at cross purposes again. So I'm interested in just domestic violence cases and the family consultant's role in relation to those cases, what are the new features of this evaluation model compared to the
I would have
processes that
to
used
take
to
it
be
on
employed?
notice, Senator, because I need to go back and compare. There are a number of guidelines for various stages of the engagement by family consultants with clients, from the early counselling through to what is done for preparation of a forensic family report under Section
Yes.
62G, different stages. But there's so in order to give you an informed comparison, we'd need to take that on notice
Okay,
and
thank you. I look forward to
distinguish
that,
for you.
particularly which phases the new evaluation model will apply to, given that, as you say, there are so many different phases, apparently with different guidelines applying to each phase.
Not necessarily different guidelines, but the considerations, because the process and the outcome is to be different.
Yes.
We go from what may be just a very limited memorandum assessment to get a sense
Yes,
of what are the
depending on
presenting
the facts of
issues
the
through
situation,
to
of course.
a report for a trial where the evidence is distilled much clearer and the much broader picture is considered in a forensic way by a family consultant, having regard to everything, and of which they can then be called as a witness to be cross-examined and to make recommendations to the court as against a very limited snapshot
I
of the
understand.
family.
It's a sliding scale. Thank you. So given that the court's now got this plan to hand, you've received it today, and you will come back to me with further detail on how you will consider implementing it, although you've outlined that process with the Joint Committee and you flagged the Chief Justice's Policy Advisory Committee. Any further detail would be very welcome. Senator, if I could ask you, Nigel Scullion, if I could ask you what response the government is intending on making to that same 5-point plan. I understand the attorney's left the room, so with the information that you have available, are you aware whether the government is across that plan and if there's any reform proposals being considered?
So the question you're asking is when, is that correct, that you'd expect the government to respond to that report or to actually implement the plan?
Well, either. Have you seen it? Is it on anybody's radar? Are you considering it? Might there be some reforms to come?
So is
because
there
the
anyone at
court's
the table
obviously thinking
can
about it.
assist me in that?
Hello, Tamsin
Hello.
Harvey, Acting First Assistant Secretary of the Civil Justice Division. Senator, we in the department are certainly aware of the 5-point plan and have been considering it as we provide advice to the government. For example, the attorney mentioned earlier the $30 million $30 million that was announced during the election around the third action plan. So that's one of the things that we considered in that advice that we provided to government.
Okay, and so what stage is that at the minute? Sorry, Minister.
I understand the third action plan is fairly close, so I don't have details about when that will be announced.
Okay, so you're saying if any of these reforms will be implemented by government, that would show up in the third action plan, which is yet to be released.
I wasn't being that specific. I was saying we
right.
did take that into account in formulating that advice, and that was around the $30 million around legal assistance. There's clearly a range of things that are covered in the 5-point action plan, which fall outside of legal assistance.
Well, there is in fact quite a lot that fall outside any action plan because many of them are statutory reforms. So has there been any input, any process on foot, aside from the third action plan, that might actually lead to some legislative reform that could give effect to these, any of these 5 steps?
We've certainly considered the steps that are in there, but any changes to the Family Law Act will be a matter for the government, so I can't provide any further advice on that.
Okay, I know I'm not allowed to ask you what advice you're providing. I'm aware of that, but I guess I'm trying to understand, has this been put through a pathway, except for the third action plan, which is all well and good, albeit always underfunded and doesn't have any legal backing, but is there any other process that this information has been put into that might end up in something, if that makes any sense?
So you're talking about in terms of whether there's going to be a formal government response, for example, to it?
That would be one example. Or is there a special division that considers these matters? I've never worked in the public service, so I'm not using the right rhetoric.
No. So certainly we are considering it. I wouldn't say that we have put forward a formal response to it per se, but it is one of the things that we're taking into account as we consider broader policy and other changes.
Okay. So do you expect that there will be a formal government response?
I don't know.
Not sure. Okay. All right. Well, look, I'm comforted that it's at least on the department's radar, and hopefully the attorney is also being made aware of the very simple and very effective reforms that are outlined in the plan. So thank you for your indulgence. Can I move now to
Can I
the...
just clarify something
Yeah,
for
sure.
you, if I may, for the record? When the on-notice question to you, I wanted to just clarify that the family court, it's limited to what I can do and provide to you for the 15% of cases which the family court do.
Yes.
They're quite separate arrangements and processed in the Federal Circuit Court, who run the filing registry. So it's not that we don't complement each other, but the separate administrations, separate Chief Justice, Chief Judge. So I would not want you to think that we or I could provide a response from the family court which would cover all of the family court's work between the two courts.
Okay, well, perhaps Dr Fenwick, you could also take the same question on notice so that I could get a complete picture. Thank you. And I'm conscious of the time. Just some questions on...
Was there anyone else?
Chair, I wasn't aware that there was a time limit.
We'd quite like to move to the AAT.
I'm sorry, Chair, I wasn't aware that there was a time limit. I apologise. Could I beg some more time?
Subject to this time limit all day.
Beg your pardon?
We've been subject to the time limit.
So you have
Well,
to
I've not been in this committee. I've been in other committees.
You've missed a treat, I tell you.
Well, Chair, if you could pop me back on the list if there is some more time. I do have some more questions.
Senator Waters, my procedure in all of the committees I've ever chaired is that I give an equal time to every senator, and we keep coming back. So as long
Okay.
as you've got
Well, I'm happy
questions,
to
we
stay
come
on the
back to you.
list.
But as it turns out, in this instance, nobody else wants to ask a question,
We'd like to
so
get to the
you can continue
Okay.
now.
I'll move
Thank
on.
you.
We'd really
All
like
right,
to
thank
get
you,
to
Chair.
the AAT.
Thanks very much. So some questions about the cross-examination of alleged perpetrators in domestic violence situations, which I think Senator Hinch was asking about earlier, and they go to the family court rules. So I'm not too sure whether the Circuit Court will also have an input here, but certainly yourself.
Can't cut it all.
There was a recommendation in the Productivity Commission's Access to Justice report, which obviously recommended that alleged perpetrators not directly cross-examine their alleged victims in cases of domestic violence. I understand that the government did respond to that recommendation. Is it the government's intention to implement that recommendation? I'm not sure if this is for yourself, sir, and I'm sorry, I don't know what your name is because your name tag's not there.
John Fitzgibbon.
Fitzgibbon.
I'm sorry, I don't know, I would have to say, in that regard, as to what the government's intent might be.
Ms Harvey, is that one for you then?
Sorry, Senator. So you were asking about cross-examination.
Yes, so the government's response to the Productivity Commission's Access to Justice report, they responded in particular to the recommendation about not directly cross-examining alleged victims by alleged perpetrators. Could you refresh my memory on what the government's response was, and could you answer for me if there's an intention to implement that PC recommendation?
Certainly. I don't have the response in front of me, but my... Oh, there you go, now I do. Thank you. So the government response acknowledged that cross-examination of victims of family violence in family law courts by the alleged perpetrators of violence can be traumatic. And we also noted, it was also noted that the department convened a roundtable discussion, which was held earlier this year, to bring together a range of different stakeholders to talk about that topic, and that was held in March. And that brought together a range of people in the family law system to talk through the different issues. It is an issue that is complex because of the different nature of family law as a civil proceeding, for example, as opposed to state laws around criminal proceedings, where there are different roles around, so different involvement of the victim, for example, in a criminal trial where they would be a witness, as opposed to a family law matter where they are a party to the proceeding and are there for the entirety. So, so some of the issues that were considered were around legislative change, for example, and that, of course, would then require additional legal assistance to fund the parties who would be appearing in the matters. So other things that are perhaps useful in this regard, you might be aware of the Family Violence Bench Book that was commissioned, and part 1 of that was released earlier this year. There's a part in there around courtroom proceeding and fair hearings and safeties to certainly bring those matters to the attention of judicial officers, so that they can use the provisions that are available, for example, in the Family Law Act or other pieces of legislation.
Okay. So is it your view that there'd need to be an amendment to the Family Court rules or indeed to the Family Law Act in order to preclude direct cross-examination of victims by alleged perpetrators?
I would have to consider whether it could be done simply by rules alone. I don't know. I'd have to take that on notice, whether it would be a rule change or whether it would be a more legislative change. It is a fairly significant change to the way that trials would run in the family court.
So you're saying this, and I'm sorry I missed it, it was a round table in March, was it?
It was.
Okay, so the round table's considered this. It might have ended up in the bench book, but what's the process now for whether or not actual amendment to either the court's rules or to the Family Law Act as relates to this cross-examination point? What's the process that would be followed, and is that process being followed in order to achieve that change?
Yes, so certainly it's something that we're continuing to consider about about what options might be available and what those options might look like.
Okay, what's your time frame on that consideration?
I don't have a current time frame, Senator.
Okay, so there's no deadline you're working to, so it sounds
Not
like
at
it
this
could
time.
take an awfully long time.
It may take some time. It is a complicated issue.
Okay. All right, look, I'm conscious of the time, so I'll move on. Perhaps this is one for yourself, Dr. Fitzgibbon. How many people were unrepresented in the family court last year?
I can check that for you. We've just done a figure. There's pardon me. It varies at different stages, Senator, and I could give you the figures that stretch across filing at first instance, the appellate division, and certainly the annual report does, as far as it is able, set out those figures for you. I would be able to
I can go and
refer you
check
to
that
them.
then, given that the clock's ticking, so if that's all in the annual report. Does the annual report specify whether those matters have domestic or family violence allegations? And I'm interested in particularly the level of unrepresented litigants where there are domestic violence issues.
I would need to look at that more carefully. I wouldn't want to give you a definitive answer about that percentile. We're certainly aware in terms of notices of risk, and it's assisted by figure of 3.20 in the annual report on page 3. Proportion of litigants represented status, financial cases, finalised cases, I apologise. So those tables throughout there, and family violence, it's all addressed at page 56, 57 and onwards of the annual report,
wonderful.
which was just tabled, I think, about a week or so ago.
All right, look, I appreciate that. I'll go and look up those figures, and I might submit some further questions on notice to get some more detail. Are you aware of the impending reduction in funding to the community legal centre sector of 30%? Due to kick in July of next year?
Not insofar as the broader picture, no, I'm not, Senator.
Okay. So you've not had any engagement on behalf of the court with the community legal centre sector?
Not in the capacity in which I am. I've only been doing this since 1 July. Otherwise, I've been sitting in court.
Oh, I see.
Yes.
Has your predecessor engaged with the CLC sector in relation to those funding cuts?
I don't know about directly, certainly, and to that extent I can't give you a definitive answer, I'm sorry, about the extent to which we've consulted very widely or we have input with them, but no, most likely not.
Have you formed a view as to whether that will impact upon the court's work, that funding cliff?
I don't know is my answer, I'm sorry. I think that there's always a demand for advice and assistance. It's limited. For the family court work, I think it's more limited as to what what they can do and provide in terms of representation in very
Indeed.
complex cases.
Well,
They
indeed,
do their
and
very
hence my-
best, but it's very complex.
And hence my question, are you concerned that there will be 30% less funding that could contribute to even more unrepresented litigants in your
I couldn't
jurisdiction?
venture an opinion about whether it would change things significantly or not, Senator. I think that there is parties. It's a different cohort of those clients who file and are present to the Family Court of Australia with very complex matters and informed by not just family violence but psychiatric disorder, drug abuse, a range of things which can impact and impair on how their case proceeds and moves. It's a very difficult area in terms
Indeed,
of
and surely the
getting
need
that
for
advice and
representation to
assistance.
assist.
Those agencies who are engaged do their very best to provide advice to them, and I'd
Well,
like
they'll
to
have
think
to do
they
their very
provide
best with
assistance.
30% less funding is my point, and
I don't know.
you've not
I
turned
can't
your mind
answer.
to the
I'm afraid
impact
it's
of
for the
that.
government.
Okay, I might suggest that you,
We don't
if you
fund
could
them.
keep an eye on that. No, I know, sadly, neither does the government anymore, or at least not as
Can I
much as
just
they used to.
intervene
If you could,
for a second, please. We're about to go to dinner at 6.
okay.
Senator Waters, if you
Yes.
only have a few
I do,
questions
thank you. I'll wrap up
for
by 6,
the
Chair.
courts, we'll stay until
Thank
you're
you, yes.
finished.
I'll wrap up by 6.
But if you don't, we will come back with the courts
Okay.
at 7 o'clock. So,
No, I'll finish up if you...
Okay,
thank
thank
you. Dr Fitzgibbon, is the court considering any early resolution of small property disputes via a legally assisted dispute?
That would be a matter for the Federal Circuit Court because
Or Dr
they
Fenwick
would,
then?
we deal with the more
With the
complicated.
30 seconds remaining?
Sorry, I'm not
Is
clear
the
what the
court
question is.
considering any early resolution of small property disputes under 100,000, as
I'm
can
not aware
often
of-
be?
I'm not aware of that initiative. I don't quite know what you're referring to.
So you're not considering a fast-track process for those much smaller property claims?
I'm not aware of such an initiative.
Okay. I will. Thank you. And just in relation to the length of time for family court cases, can you give me an indication of whether obviously every case is different, I understand that. Are they taking longer in recent times, or is the court getting more efficient? How long is a piece of string when it comes to an average family court case where there are domestic violence issues?
I think probably, given your time constraints, there's a comparative table within the things, and the CEO can give you an answer about that aspect, if I may.
Sorry, Senator, just in terms of the timing, filing the first day of trial is 16.7 months of those that go to trial. Filing to finalisation is 12.3 months in terms of the figures you're asking for.
What's finalisation if it's before the trial?
No, well, the difference with those two being the 12.3 being smaller is because many of them settle actually before trial.
Okay.
So
what's
effectively-
filing until judgment date?
Sorry.
What's the period of time from filing to judgment?
Filing to judgment is. Do you have that? Sorry.
Or if you like, the time from the trial to judgment?
So we've got those two components, Senator, so I might take that final one on notice where you want the actual differential
Okay,
there. I don't
thank
actually
you.
have that
And I'm
there.
interested in whether that amount of time has increased in recent years or decreased, just the trends there. Can you reflect on why the length of time? Because my understanding anecdotally and through communication with the sector is that domestic violence cases seem to take particularly long time, given their complexity.
Well, again, I'd ask Fitzgibbon would need to discuss that. in terms of the process, so I'll just swap.
Okay. I'm just interested in the cause of the delay. Is it, and you know, I'm sure it's a mixture of things. Is it the court? Is it underfunding? Is it the parties? Is it the complexity?
So you've identified some of them. There are no single factor, in my view, in my experience, Senator, is the cause. There are extraneous factors. On occasion, there are delays to get experts who can prepare particular reports to assist the court. There may be police investigations, inquiries and proceedings, a whole range of things, and of which the family violence element is one important presenting aspect of the case amongst a range of other matters. But we endeavour to keep very close tabs on matters moving along a pathway, and also upon when they are finalised, if judgments are reserved and the timelines for those. So I don't have a sense that there has been any really significant increase nor decrease. It can vary from the size of the registry, the state, the region, judicial availability, and so on. And it's and again different for the Family Court of Australia than it is for the Federal Circuit Court of Australia, with different processes. And the Federal Circuit Court services all the regional circuit areas as well. So delays vary around the nation depending upon the nature of the work and its locale and so on. It's So
just one last question. Thanks everyone for your patience. Do you track specifically the length of time for those domestic violence cases? Do you
not that I'm
separately
aware
flag them?
of, in terms of a specific case that's noted as such and then followed.
Okay. All right. Look,
That
thank you very
will be part of the overall evidence in a case.
Okay. Thanks very much for your help. Thank you, Chair, for your patience.
Thank you very much, Senator Waters. Thank you to the officers of the three courts. Appreciate your attendance, and thank you very much. We will resume at 7:05 with the Administrative Appeals Tribunal. I just indicate that following that, I'm not